Hello and good day, everyone. This is to warmly welcome you to the 15th edition of Legal Insight. Today is Sunday, the 24th day of May 2026. In this edition of the program, we will continue our discussion on incorporated companies, and today's topic of discussion is promoters of companies. Now, who are promoters? Promoters has been defined by the Companies and Allied Matters Act, CAMA 2020, to mean persons who undertake to take part in forming a company with respect to a particular project and take necessary steps toward accomplishing that purpose of forming the company. Promoters also include persons who now came in with respect to a newly formed company or proposed company to raise capital for the company. Now, from this definition of CAMA, there are two categories of promoters. The first category are those persons who, where there is an idea of forming company or there is an idea of setting up a business, they will now come in and then take part in forming the company. The other category are those who, where a company has been formed or where a proposal for the registration of company has been made, they will now come in with respect to raising capital for the company. It is, however, important to note that persons who are engaged in a professional capacity towards forming the company cannot be considered to be promoters of company. For instance, a lawyer who is engaged to register a company with Corporate Affairs Commission cannot be regarded as promoter of a company because he is being engaged in his professional capacity as a legal practitioner to register the company. Now, because promoters carry out their activities before the relevant structures of the company are put in place, and they also act on behalf of the company before its formation, the law requires promoters of company to observe utmost good faith in any relationship or in any transaction for or on behalf of the company. This means they are in a fiduciary relationship with the company, and where any loss is incurred by the company because of their failure to observe utmost good faith, they will compensate the company. It is also important to note that where a promoter acquires any property or information in a circumstance in which it was his duty to acquire it on behalf of the company, the law mandates such promoter to, account to the company such property and information and any profit derived therefrom. Now, the rationale of this provision is to prevent a promoter from making secret profit out of a property or information acquired for the purpose or on behalf of the company. Now, in a situation whereby a promoter enters into a transaction between himself and the company, such transaction can be cancelled by the company unless, after disclosure of all material facts relating to the transaction by the promoter, the company decides, to ratify such transaction through either the board of directors or the annual general meeting of the company. Well, this brings us to the conclusion of this edition of Legal Insight. If you find it interesting, follow the page for more interesting editions. Thank you.